Yes, Your Honor.
Very well. This is a time set for oral argument. In our case, CB 190744, Navigators versus First Mercury. Counsel, good morning. Each side is given 20 minutes for oral argument. Mr. Highland, if you wish to reserve a portion of that for rebuttal, feel free to do so. In more normal times, you'd have a beautiful sort of podium clock that would allow you to do that. I actually have an Apple phone that I'm keeping time on. So if you're approaching 20 minutes, I will let you know, but you'll need to keep track of your own time, and I will backstop that as well. We have read your briefs. We're familiar with the record. We've conferenced the case. We'd encourage you to keep that in mind as you do present oral argument to us today. Please also, to avoid feedback when you're not speaking, make sure you mute your microphone. And if we can't hear you, we'll let you know, because we want to hear everything you have to say to us today. Proceedings are being recorded, so please, as you begin your presentation, announce by telling us your name and the party that you represent. With that, Mr. Highland, you may proceed.
Thank you. Good morning. May it please the court. My name is Tim Highland, and I represent the appellant, First Mercury Insurance Company. This case presents the question of what is the required factual and legal basis to establish a prima facie case for a bad faith failure to settle in an equitable subrogation claim brought by an excess carrier against the primary carrier. In this case, there is no evidence of any unreasonable actions taken by First Mercury in its handling of the defense of the underlying case. In fact, it is undisputed in the record that First Mercury, as the primary carrier, defended the insured in the underlying lawsuit, performed a fair and adequate investigation and analysis, hired experienced defense counsel, hired appropriate experts, considered and followed the advice of defense counsel as to settlement and verdict value, followed the advice of the settlement and trial judge as to appropriate verdict value, kept the insured informed as to the status, and even inquired of the excess carrier if it knew of any basis or any factual support for something that it had not considered or needed to consider. In fact, the only thing the record shows that First Mercury did not do was accurately foresee the ultimate jury verdict. And Arizona law is clear that it is not the responsibility of the insurance company to prophesy the verdict. The failure to correctly guess the verdict is not bad faith conduct. Arizona law only requires an insurer to give equal consideration to the insured's interests in deciding whether to accept a settlement offer. In looking at the insurer's conduct, the Arizona Supreme Court has set forth the Clearwater factors to determine whether or not the carrier is acting with equal consideration. In this case, there's only really two factors we need to be considered or concerned with. Factor one, the strength of the insured's case on liability and damages, and factor six, the amount of financial risk to which each party is exposed. And that's because those are the only two factors that Navigators has argued shows any bad faith conduct by First Mercury. And while we agree that the determination should not simply be a numbers game, we do think it's worth noting that 3/4 of the factors that the court has set forth, Navigators admits doesn't show anything improper at all, even under their argument, by First Mercury. What Navigators and their expert asserted with regard to factors 1 and 6 is that First Mercury did not basically consider with significant weight the potential for an excess verdict and some potential loss or financial risk to Navigators. But both Arizona law and the record compel a different conclusion that what First Mercury did was correct. First, Mr. Guy, Navigator's own expert, testified that First Mercury did a fair and adequate investigation of the claim. Further, it is clear that First Mercury's defense counsel and First Mercury's claim adjuster, when they evaluated settlement, considered it a lost case on liability, considered 100% liability loss. And they used, First Mercury did, in their evaluation, the full claim of plaintiff's demands and damages as the potential outside of a verdict. So everything was considered. Mr. Guy's opinion was that First Mercury didn't sufficiently consider the potential strength of the damages case and the financial loss simply because we didn't give enough consideration to the fact that there may be a loss or a risk to Navigators' policy. First off, our opinion is that Navigators' potential risk doesn't matter because the law set forth in Clearwater under the factor is it's the risk of financial loss to the party. So it was the risk to LA Fitness, the insured. And LA Fitness had no risk of financial exposure because they were fully insured.
And under that point of view, Mr. Highland, excess lines carrier could never sue unless the verdict exceeded their coverage. Is that what you're saying?
No, that's not what we're saying. That's how Navigators has characterized our position. What we're saying is factor 6 doesn't show bad faith conduct if the insured doesn't potentially suffer or risk any financial loss, because you're looking at it from the perspective of LA Fitness. So factor 6, the exposure of the parties, LA Fitness has no potential exposure because they're fully insured. That factor doesn't apply. It's not a bar or a ban to potential bad faith liability.
And Clearwater was not a excess lines case, correct?
Correct. That's but of course, well, and we'll get to it. What the position in the fight here has been is about what duties in an equitable subrogation case, and those are excess carrier cases. But Navigators argues that First Mercury is gambling with Navigators' money.
Let me ask you a question. Is Clearwater is this a conjunctive test in which you have to meet each and every factor, or are you just sort of picking one of several factors and saying that doesn't apply? And if that's your argument, then why? I guess how are we able to ignore a jury verdict here?
Good question, Your Honor. First off, the test is generally whether a reasonable and prudent insurer under the circumstances would have accepted the settlement offer. The Clearwater factors are a list of factors that a jury and a court should consider in determining whether or not the carrier acted appropriately in giving equal consideration. So you consider the factors to see, was the conduct unreasonable? And why we're only talking about 2 of the factors is because Navigators agreed that, or well, at least only argued that 2 factors showed any evidence of, or under their argument showed evidence of bad faith conduct. That was what their expert testified to. That's what their position was. Their expert conceded that the other factors didn't show any evidence of bad faith. And so now when you get to the jury verdict issue, and I'll jump ahead for that, Your Honor, it's true that the case went to the jury and the jury rendered a verdict against us. We don't believe it ever should have went to the verdict for all the reasons we're talking about. But the reason that the jury verdict is improper is because of the highly prejudicial jury instructions that were given, or actually failed to be given. The jury was given a couple instructions as to how to evaluate whether or not there was bad faith conduct, but was not told what under Arizona law does not constitute bad faith conduct. And Arizona law is clear that, and the court refused to instruct the jury that there is no absolute duty to accept a settlement offer within limits in order for the primary carrier to avoid liability for an excess verdict. They didn't know that there was no duty to do that. And more importantly, they were not instructed that they couldn't use hindsight in considering the reasonableness of the jury verdict, because the jury knew and was told that the ultimate verdict was 3.95 million, twice the amount of First Mercury's insurance policy. So in hindsight, it gets really difficult to say, how is that not an unreasonable decision? And they should have been told that they couldn't consider that because that is the Arizona law. You can't apply hindsight. And that was made even more prejudicial by the conduct of Navigators at trial.
Mr. Highland, let me ask you on the jury instruction before you get to that next point. What's your best published case saying those instructions had to be given? Because they're not Raji's, I don't think. Now that doesn't end the inquiry by any stretch. But what's the best case that a jury had to be instructed about what was not bad faith?
Well, Your Honor, I'll be honest with you. I don't have a case name at the tip of my tongue, but the case law I'm relying on.
I feel a little better because I haven't found one either.
But the fact of the matter is, they are correct statements of law, and there was testimony and evidence and facts and legal theories at trial that justified explaining to the jury those points, and especially the one that we're talking about, that they can't apply hindsight. Because if they get to apply hindsight, then the jury gets to apply something that First Mercury never knew. That's the whole basis why they can't be held to have to predict it. And like I said, oh, go ahead.
Let me push just a little bit on that, because the hindsight issue, it seems like would always arise, right? Something went bad. And regardless of whether there's a villain here or not, something was surprising, right? Isn't that always the case with a bad faith claim?
Well, it's
or
always
often the case, I should say.
Well, it is probably going to be the case in this type of situation, a failure to settle. But the fact of the matter is, that's why it's so important that the jury gets told, you have to put yourself in the place of First Mercury before the verdict. What did you know? What did you evaluate? What were the facts? And not put yourself sitting there at the jury saying, you guys really blew it. And that's why they should have been told that. They should have been told, even though you know the verdict, it's really important not to evaluate the reasonableness of First Mercury's conduct with hindsight. And as I was going to say, that gets exacerbated by the closing argument of Navigators. Navigators tells the jury in closing argument, which is quoted, I think, in a footnote in our reply brief, they say, quote, and what really proves the risk? It's Exhibit 23. Exhibit 23 was what an Arizona jury said 4 years ago in February 2015. Whoops. Oh, yeah. So the jury came back at 3.95 million. So Navigator's whole position that we didn't adequately consider the risk of an excess verdict or excess exposure loss to them, they told the jury, look at the verdict. That shows the risk. And that's totally improper. That's applying a hindsight standard. And they not only invited the jury to do it, the trial court let them do it by not instructing, but they told the jury to do it. We also don't have the jury being told that it's clear Arizona law that it's not bad faith for an insurance company to make a mistake in judgment if they do it based on an adequate investigation and adequate knowledge. Here, Navigators and their expert did not say we didn't do an adequate investigation or have fully evaluated the claim, and we made a mistake. But it was a mistake that we weren't the only ones that made. The defense counsel never thought the case was going to be anywhere close to this. He valued it $800 to $1 million. The trial judge valued it at $1 million. We went all the way to 1.1 million. Navigator's own adjuster testified that she had no information that it was higher than 1.1 million was a fair settlement value, had no information that it was going to exceed the primary limits, and had no information that even 1.5 million was a better settlement position than what we were taking at 1.1. In fact, she was relying on the exact same recommendations of defense counsel, and based on that said, I'm not going to the settlement conference and I'm not coming to trial because I see nothing outside of your policy limits. The financial risk and exposure issue is only the fact that there was some chance. Yes, the plaintiff was going to ask for $4 million. But defense counsel had analyzed that over and over again, not only himself, but in roundtables, and come to the conclusion and told First Mercury that there was a 20% chance that there was going to be a verdict over $2 million. There was an 80% chance, in his opinion, not just of a verdict under 2 million, but under 1.25 million, a $750,000 cushion on their policy. If that becomes unreasonable failure to settle or an unreasonable exposure of financial loss, then you're never going to be able to, as you said, Judge Thamba, it's always going to be, if there's a surprise verdict, and you didn't settle because there was an offer, that you're in bad faith, because it doesn't matter whether there's an 80% chance that you're going to be within your policy limit or a 95% chance or a 50%. It becomes the issue of what's reasonable. If there had been an analysis by defense counsel that he thought the exposure here was 1.75 million, but there was a 50-50 chance that it was going to go over 2 million, then maybe there's an unreasonable exposure that you're subjecting the insured and or the excess carrier to. But when you're being told that there's an 80% chance that it's not only within your policy, but almost $1 million worth inside your policy, then you that should be not an unreasonable position to take, that we're not going to that we don't have to accept the settlement offer that we don't believe is reasonable. And
Mr. Highland, the
go ahead.
facts that you have just described were presented to the jury in this case, right? I mean, you're not claiming that evidence was impermissibly excluded. Your challenge is to the jury instructions. Is that fair?
Right. Well, yes, it's really twofold, and I'm sure you understand. First off, we're saying it never should have went to the jury, that they can't make an evidentiary basis here. But assuming that it was appropriately sent to the jury, then the jury's verdict has to not be followed because of the fact that the jury wasn't properly instructed on how to interpret that evidence.
I understand. I just want to make sure there's no challenge by your client that there were evidentiary errors. It was the case should not have gone to the jury, and if it did properly, the instructions were improper.
Correct. And Your Honors, I'm going to try to save a few minutes here, but I think you really need to look at City of Glendale versus Farmers Insurance Exchange. That's really instructive because in that case, there was an automobile accident and the passenger sued the driver in the City of Glendale saying there was road issues that she was unaware of and went off the road. There was a $100,000 policy. The carrier did an investigation and offered $25,000 based on the fact that the plaintiff was speeding and there was good case law in favor of the city. The city even sent letters to the carrier saying, please offer the $100,000, and the plaintiff demanded $270,000. They didn't do it. The verdict came back at $280,000. And in that case, the court directed a verdict on the bad faith claim, and that was upheld on appeal because of the fact that an insurance carrier should not be required to offer money when a good faith investigation shows a different settlement value. And that's exactly what happened here. Every single person that evaluated this claim thought it was within the policy limits and also believed that there was cushion, that there was not even a settlement value up to $1.5 million. And that's why this case is so important, that a primary insurer needs to have the ability that if it properly defends a case and appropriately evaluates it, that it's not going to be subject to exposure for excess liability and judged in hindsight just because it didn't predict a runaway verdict. And I'll reserve my remaining time, Your Honor.
Thank you. And Mr. Highland, by my rough math, I have about 2 minutes and 45 seconds for your rebuttal. So, Mr. Raymond.
Thank you. May it please the court. My name is Michael Raymond, the law firm of Raymond, Greer, and McCarthy. I represent the plaintiffs in the underlying case, the appellee Navigators Insurance Company, which was the excess insurer. This case is not about a mistake. It is about a considered decision not to settle in spite of a known risk, a risk of a substantial verdict in excess of First Mercury's $2 million policy limits. Very capable counsel on the other side, both at trial, and these arguments were all made to the jury. They rejected them, and I feel mostly because the jury focused on the test. The equal consideration test is whether a prudent insurer without policy limits would have accepted the settlement offer. And the jury concluded in this case with the potential for a $3 to $4 million verdict, a known exposure of $4.2 million, that a reasonable insurer, when it had an opportunity to settle on the first day of trial for $1.5 million, would have settled the case, particularly with the valued at 1.2 million, 1.28 million actually was the expected evaluation of First Mercury, and that the delta, the difference between the 1.5 offer and the 1.2.8 so-called expected verdict was so small in comparison to the risk of an excess verdict. That's what the jury determined, and they focused on the test. The evidence revealed that First Mercury had multiple opportunities to settle during trial within their policy limits. I do agree with Mr. Hyland that we focused on the two main features of Clearwater, and if you look at the Little case, very similar to our case in that Little, most of the other factors didn't apply. But when you're talking about equal consideration, when you're talking about evaluating opportunities to settle, you have to look at least the two main factors, which is the first one is the strength of the case on liability and damages, and the other is the amount of financial risk to which each party is exposed in the event of a refusal to settle. Here, defense counsel recognized, albeit I think he was a bit conservative, but he recognized a $2 to $3 million verdict possibility. First Mercury's own investigation, which was Exhibit 7 at trial, which you probably don't know this, but was a blow-up at trial. There was a chart prepared by their adjuster recognizing a potential $4.2 million award. Now, they said that that's high, but the reality was that First Mercury was not going to be able to prevent the plaintiff from introducing economic damages of about $3 million. They were going to blackboard 2.6 to 2.8 million in loss of future earning capacity. And they also knew that the plaintiffs would likely ask the jury for an award of between $3 and $4 million. And here's the other thing. Unlike most cases, like the Little case, where the defense counsel said there was a 60% chance of a defense verdict, and the court said, well, that's nice, but it doesn't really recognize the 40% possibility of an excess verdict. Here, liability was virtually certain. Ms. Poff, the adjuster, said it herself best when she said, no one gets on an exercise machine and expects the chain to break and for you to fall off. It was a serious injury case. Mr. Wiley had 3 surgeries. It was all agreed he could not go back to work in a very favorable.
Counsel, go ahead and finish that. I'm sorry. Did I cut you off in the middle of a sentence there? You want to finish?
I was just going to say that given the clear liability and the potential damages that were well in excess of First Mercury's limits, in fact, potential for $2 million in excess, this evidence alone was sufficient for the jury to conclude that the failure to settle within limits was unreasonable.
So counsel, let me ask you, the way you frame the test, it is exclusively focused on the primary insurer, almost making the excess insurer relevant the way it's framed, whether a reasonable insurer would have, and then you filled in, settled. Is that the law? We don't really consider whether the excess insurer asked to be kept informed or asked, and I'm not saying that the excess insurer here did or didn't. I don't believe the adjuster attended trial, but is that the test? Is it exclusively on the primary without any consideration of the excess insurer's request to be informed or even care about what's happening?
Yes, and that's because the Hartford case instructs us that until the primary insurer offers its limits, the excess carrier has no duty to act, no duty to defend, no duty to even consider an evaluation of the case. They don't have the right to control settlement. The only issue that one of our cases instructs, and I can't remember if it's Hartford or the Twin City case, is that if the insurance company, the excess carrier, hinders the primary insurer from settlement, that could be a factor. There was no evidence in this case. In fact, the reality was here that before trial, the disparity between the offer, which was around $380,000, and the demand, which was $2.7 million, really just made the excess carrier have to sit on the sidelines. It was not until the first day of trial, and parties do get more reasonable at that time, that the offers raised, the demands are lowered, and lo and behold, it's within policy limits. And so the so-called hammer letters were sent. That's the industry term. I don't care for it, but but the excess carrier need not even send that hammer letter. They don't have that responsibility. And here's why: because the primary carrier has absolute control over the settlement. They have that right to decide on settlement offers. The excess carrier doesn't have that right. The insured doesn't have that right. But because there is that power, we ask that primary carrier consider reasonable settlement offers within its policy limits when there is a risk of an excess exposure, because the judgment, the excess judgment, is going to be against LA Fitness, or in this case, an excess carrier that has no control. So because we give them that control, that primary carrier, they have to abide by the test of equal consideration. And Judge Weisensweig, your question is, no, you can't consider the fact that there's excess insurance. It just doesn't work. It would gut the doctrine of equitable subrogation.
Mr. Raymond, let me ask you, sort of almost by its name, a bad faith insurance claim seems to imply something that is atypical, extreme, however you might want to phrase it. Tell us why, if with that premise, tell us why this is such an extreme case.
Well, I guess that's a good question. Extreme case. I guess I may take a little bit of issue, Judge Thumma, with the issue of whether it has to be an extreme case. It basically just has to be whether a prudent insurer would have settled the case. I don't think we need to prove that First Mercury was a bad actor, that they had some sort of evil mind. That's not what the equal consideration test reflects. And that's, we've had Clearwater around now for, 30 years. It came out the same year as Hartford versus Aetna, and then the companion case. So we've had this law for 30 years. And in fact, Clearwater, if you look at it, they go through an excellent analysis of why the fairly debatable jury instruction that was proffered in that case was not proper. It's not a fairly debatable issue. And in fact, the Little case from 1969, footnote 4, you have to kind of dig for it, but there the court rejects the mistake argument, that the carrier's not in bad faith if they make a mistake. I mean, the reality is that what we want to evaluate is the settlement offers. After the verdict, we can all say, well, the insurance company didn't get that one right. I mean, who can say whether a jury is going to award $1.28 million? No one can. The issue is the comparative hazards. And here, the comparative hazard, the risk of an excess verdict, was mammoth. If you take a look at all these cases that went to a jury, that our courts have held, the trier of fact could determine whether or not this was a bad faith case. Henderson was an excess verdict of $5,000. Hartford versus Aetna was an excess verdict of $115,000. Little was an excess verdict of $12,000. All these cases are in the 4 to 5 figure cases. Our case is a 7-figure case, and it's a crooked number 7-figure case. So the exposure here was massive, and the jury could have certainly considered that what they knew at the time of the settlement offer, and that evaluation was a pretrial evaluation, Exhibit 7, that suggested, hey, and the reality is, here's what happened, is that, First Mercury wanted to believe its own experts. But the reality is, as we know, the jury, the first jury, if they believed the plaintiff's expert, it was going to be a big award. Everybody would have to know that. So there was substantial risk here. But to your question, Judge Emma, I guess I have to take issue. I don't think it has to be an extreme bad conduct by the insurance company. I don't think they're bad people. I think that they just did not consider this risk. And here's what they did, is they knew there was excess insurance. And they've argued that in the trial court. They argued it to the jury that there was no exposure to LA Fitness, therefore we should win. That's not the law, but they were allowed to argue it. If this case had gone to the other way, we'd probably be up here talking to you about that. But and let me say one thing. I don't know where I am on time, but on the jury instructions, and I guess I kind of covered it, because Little rejects the mistake, honest belief. And the other thing about the hindsight test, and that they said was highly prejudicial, it's adequately covered in the Clearwater instructions. The jury is to consider the insurance interest as it gives to its own when it considers a settlement offer. You actually look at the jury instructions, which I'm trying to find. It talks about the test is whether the insurer should have accepted a reasonable settlement offer at the time it was made. So it's got nothing to do with the jury verdict. It's got, what did you know at the time of the settlement offer? And that was the first day of trial. They knew that there was a $4.2 million exposure. They also had to know that if the jury believed plaintiff's expert witness, that it was going to be a big number. It was going to be well above the $2 million limits. I'm not sure I have anything further unless the court has any questions.
Look to my colleagues. Any questions? No. Thank you. Thank you, Mr. Raymond. Mr. Hyland, rebuttal.
Yes. Let me start first with the questions of the court. Judge Thuma, you asked about whether or not there needed to be anything extreme. And in 2003, 13 years after, we're talking Hartford and Clearwater and Twin City Fire, the Arizona Supreme Court in Twin City Fire v. Burke is looking at a case, and it's over the attorney-client privilege, but it covers both what you and the other court members asked. It says, to prove a bad faith claim based upon the failure to settle, a plaintiff must demonstrate that in the investigation, evaluation, and processing of the claim, the insurer acted unreasonably and either knew or was conscious of the fact that its conduct was unreasonable. So even though it's the equal consideration test, the element that's always present in bad faith because it's a tort is required. And in that case, the court also went further and looked at what was asking about the excess carrier. And it says that while they weren't going to compel disclosure of the excess carrier's attorney-client communications, that the importance of whether the excess carrier valued the case the same way was relevant and of pragmatic importance, because if the excess carrier valued it the same exact way, then it demonstrates that it was not unreasonable for the primary carrier to do it. So 13 years later, they clarify those points and say that you need the bad conduct, and if the excess carrier is doing the same thing. And with regard to the jury instruction argument that was just made, that it was covered, you need to look at how that instruction is written. In the second paragraph, it says the duty of good faith requires equal consideration when it considers the offer. But then it goes on and says the test, now it tells them what the test is whether does not say that the test itself has any sort of time limitation. And
Mr. Hyland, would you do me a favor? The last 15 seconds or so you cut out, and I want to know what you were saying. So you were talking about the test.
Right. The second paragraph of the jury instruction states you give equal consideration. The third paragraph says the test is whether or not a prudent insurer would have accepted the offer. And it doesn't say would have accepted the offer based on what it knew at the time. It just says would have accepted the offer. So it told them the test did not have a time limitation, or at least it left that open for them, and they were never told that there was. And the last thing, Your Honor, is the emphasis has always been on the fact that the First Mercury knew there was a potential exposure of $4 million, and we acknowledge that. But it can't be that we're in bad faith simply because the plaintiff is going to claim either an argument or some assertion that there's that amount of money. The question has to be, what is a reasonable determination? And that's what we don't, as long as we've done it on adequate facts, if we make a mistake on what the jury ultimately finds, it's not. And I think if you go read Little and Fulton v. Woodford, you're going to see that's still the test. It's always been the test in all bad faith cases, that a mistake upon adequate information is not bad faith. I think I'm out of time.
Counsel, thank you. Thank you both for your briefing, for your presentation today. We appreciate it. You've given us much to think about. We will take the matter under advisement and we'll issue a written ruling in due course. Court stands adjourned. Take good care.
Thank you.